So the next speaker, before we get to the proper meat of the matter, which is where we will now begin to take questions, and those questions that have been bothering you, please write them down that you do not forget. I am calling on Dubem Okadigbo Muoghalu Esquire, who is the Special Assistant Research and Public Policy to the Speaker, House of Representatives. I must note here, it is very important here that that we bring him in. His boss was the one who brought in, or rather, who proposed the act that is causing too much tension in the country. So he's here to represent his boss, and in this case, Dubem Okadigbo. We will now give you the floor to make your own presentation. I hope it's okay. Yeah, go ahead. I thought I had you now, Dubem.
Dubem registered with the name DM. Do you have it? DM.
No DM here. Okay, yeah, I've seen it. I've seen him. So Dubem, you can now speak.
Good evening, ladies and gentlemen. I thank you all for being here this evening, and I thank the organizers of this event for the vision and execution of this particular program. I want to address a few things relating to this bill so that perhaps we can achieve some clarity that allows us to move forward away from the present controversy and then focus on how we can improve the general framework for the management of infectious diseases, which is the point of this legislation. Now, the first thing I want to say is there has been a lot of talk about perhaps misunderstanding between bill and act. The first speaker who spoke referred to the Control of Infectious Diseases Bill as an act. This bill is not an act. An act is a law that has been passed by the parliament and signed by the president. This bill has not gotten that far. What we have now is a legislative proposal, because that's what a bill is. And a legislative proposal will go through a number of steps during which it will be improved on and perfected before it finally receives the necessary assent from the president. So this is a proposal. We need to keep that in mind and engage on that basis. That this is a proposal that will be improved as it makes its way through the process. Now, a lot has been made about the similarities between our bill and that of the Singaporean Infectious Diseases Act. Now, I need it to be clear for all who are on this platform at the moment that the language of plagiarism that has been attributed, that has been used in regards to this bill, is simply incendiary and is intended only to arouse certain passions. Plagiarism is not a known, is not known in legislative drafting. It is not possible for you to plagiarize an act of parliament, government edict, or court judgment. One of the principles of legislative drafting is best practice. Essentially, what that means is when you want to achieve a particular objective, the first thing you do is you ask yourself, where else in the world is there any other jurisdiction that has achieved what you intend to achieve? And if the answer to that is yes, you say, how have they achieved it? How have they achieved it in the written text? And you take that written text and use it as the foundation for your own development, for developing your own legislation and whatever sort of improvements you wish to, and you make whatever improvements you wish to make so that it is more suited to your local context. The first speaker started by highlighting the similarities and suggested that perhaps this was a verbatim replication. But towards the end of his presentation, he noted that there were places or instances where our bill differed, in fact, from the Control of Infectious Diseases Act in Singapore, because we had taken what was done in Singapore as the foundation of our work, and we had improved it and amended it to an extent that it was more suited to our own local context. Now, moving on from that, it is important to note that there is nothing that we have done in this bill or with this bill that is not based on existing law in Nigeria. We have not sought to recreate the wheel or to import into our jurisdiction practices that are unusual to us or practices that are alien to us. The Constitution of the Federal Republic of Nigeria, and I need you to pay attention to this, in section 45, gives the, the government of the Federal Republic of Nigeria the right to derogate from certain principles of human rights under very limited guidelines. Section 45 of our Constitution says that, section 45, subsection 1, nothing in sections 37, 38, 39, 40, and 41 of the Constitution shall invalidate any law that is reasonably justifiable in a democratic society in the interest of defense, public safety, public order, public morality, or public health. That is section 45. Then you now will go on to section 305, which on the section, the miscellaneous provisions, which dictate what happens during the proclamation of emergency. So we have simply sought to build on what already exists to achieve the particular objective of strengthening our framework for the management of public health. I noted some of the comments that were made by some of the other presenters, so let me address those, and I will subsequently take questions as they arise. Section 3 of this particular bill deals with the process of and the powers of the president in declaring a public health emergency. A lot of the contentious provisions that people are worried about apply only in a public health emergency. The only person under the bill who has the power to declare a public health emergency is the president. I need us to note that. We have not given the Director General power to act on his own or to act outside of norms. We have simply given him powers that come into effect subject to a declaration of a public health emergency by the president. Somebody mentioned about warrants and the power to arrest without warrant. The power to arrest without warrant is not new to our laws. The Administration of Criminal Justice Act makes reference to the power to arrest without warrant in I think in section 6 or section 54. I'm not clear at the moment what section it is. But that power to arrest without warrant already exists in our laws. Section 52 of the Administration of Criminal Justice Act grants the police express authority to execute an arrest without warrant, where a warrant, is where you cannot, it's not immediately possible for you to obtain a warrant, or where it is necessary for you to do so to prevent commission of a crime. And even under the Act, the Administration of Criminal Justice Act of the Federation, it is only reasonable suspicion that is required. So if a police officer has reasonable suspicion based on his own idea or his own knowledge that a crime is in occurrence or a crime is about to be committed, he or she can execute an arrest without warrant. Substantively, there is no difference as far as the issue of warrants are concerned between existing law and what is being proposed in the bill. Another issue that was raised, I think, was the issue of why we did not create an exemption for other written law not affected, and the issue of the courts cannot intervene oversee the bill or when it becomes an act. That is not true. The right to appear before court is a constitutional right. The right to challenge government legislation is a constitutional right, and you cannot abrogate that right by passing a bill in parliament. There is no section of this bill, by the way, suggests any such abrogation of rights. But even if it did, that will fail very quickly, because that will be in express violation of constitutional provisions that guarantee us as Nigerian citizens the right to challenge any legislation or act of parliament in the court of law. But even within the act itself, there is clearly all the offenses in the act must be presented before a court of law. That is to say, if the NCDC director, the Director General of the NCDC, or a health officer acting under his authority were to arrest an individual for violating any of the provisions of the proposed bill. It does not mean that what do you call it? That arrest automatically you automatically become subject to a fine or subject to punishment. When that arrest is conducted, you have a right to be brought before a magistrate court and to be tried in the court. And then the court can decide to find you guilty and impose the punishment prescribed by the act, or to find you not guilty, in which case you go home and continue your life. Then my brother, Barrister Daniel Bola, he spoke about the need to, as we are making interventions relating to public health, we need to also make interventions relating to the national economy and the economic welfare of Nigerian citizens. And I agree with him 100% that both of these things must be done at the same time. And he made reference to the CARES Act, which was passed by the United States Congress. At the beginning of this particular pandemic, even before the lockdown orders were issued by the President of the Federal Republic of Nigeria, the House of Representatives passed the Emergency Economic Stimulus Bill to help Nigerians get through this present crisis. The bill sought, amongst other things, to grant tax relief to companies who retain their staff during this crisis. The bill granted a moratorium on loans, which I understand, which is one of the things the barrister made reference to. It granted moratorium on loans, on mortgages and loans from the Federal Mortgage Bank and from the Federal National Housing Fund. That bill has been passed and sent to the Senate over a month ago, and it has not even been listed in the Senate for consideration. And at some point, I would like my brother barrister to explain to us what is holding up this particular bill in the Senate and why it hasn't been passed. Because a lot of the things he made reference to, a lot of the emergency provisions for the well-being of Nigerians that he made reference to in his presentation, we have actually addressed them in the House of Representatives, and we are only waiting for the Senate to concur and to help us make those things real for Nigerians. And I wish that the Senate had concurred before now, because already some of the mischiefs we were trying to cure, or some of the ills we were trying to prevent, have already started to occur, because precisely because this bill has not become law. Specifically, the bill, the Emergency Economic Stimulus Bill, it deferred payment of mortgages. It removed import duty on all medicines and medical goods, so that to make it easier for the NCDC or for the state governments or whoever else to be able to access the medical equipment that they require that we cannot manufacture in Nigeria here or are not readily available in Nigeria here. In addition to that, we essentially gave up to a 50% rebate on taxes, on income taxes for companies, so long as those companies maintain their staff strength between 31st of March till from the 1st of March to the 31st of December. The idea is, if you maintain your staff strength as it is, you essentially get a tax refund that allows you to be able to continue your operations even though it's minimized or whatever. So we have already taken action in that regard, as it relates to addressing some of the present needs of Nigerians, and we will still take further action as the need arises and within the powers of the House of Representatives.
Well, thank you very much, Dubem.
Then also finally, I wanted to speak to Professor Morrissey's presentation. I was delighted by some of the comments he's made and some of the things he's spoken about. In fact, I did not know up until now that some of those advancements have already occurred, and I'm proud that he, being a Nigerian, and is part of integral to that process. However, I need Professor Iwu to please, when he is responding to some of the questions, highlight specific challenges that he believes can be addressed by legislative action. Yes, we are all part of the government, but the reality is there are certain things or certain improvements that cannot be made by the legislature. There are certain things that by law and by practice, are firmly domiciled within the authority of the executive. What we have in the National Assembly is what I like to call the convening power. That is the power to convene people together and say, there is a problem, we must advance a solution before this is over. Another power we have, of course, is the power to pass legislation. So I would really appreciate it if the Professor Ewu can please highlight specific areas where he believes legislative intervention will serve the purpose of either facilitating these advancements in medical technology or improving the circumstances that will allow him to do what he needs to do for us and for the world. Thank you very much.
Thank you very much, Dubem, for that wonderful presentation. Before we go on to taking questions, and you know, with many of us are in WhatsApp groups, many of us have been seen on social media where people share this information that the bill, the proposed bill is going to be a mandatory vaccine. Actually, that is the crux of the matter. A lot of grammar has been spoken here. For the man on the street, I want you, Dubem, to address the man on the street. Is this bill with the intention to force people for mandatory vaccine that is yet to be found? And has this bill got anything to do with Bill Gates? Sorry, I have to ask that question. This is for the street and for the WhatsApp groups.
We have no intention of passing laws in Nigeria, Bill Gates or any other individual from wherever they may present themselves. We have not consulted Bill Gates in formulating this legislation or in considering some of the provisions that we have considered as part of our efforts. I speak for myself, and I also speak for my boss in this regard, and I can assure you 100% that Bill Gates has no involvement in this particular legislation. Now, speaking to the issue of vaccination, Section 30 deals with vaccination in the first instance, and it deals with vaccination for international travelers. Again, I started by saying that there is nothing in this act, that in this proposed bill, that is alien. Section 30, in fact, let me find Section 30 and perhaps we can all see what the bill specifically addresses. Section 30, subsection 1, every person on an international voyage, whether living or arriving in Nigeria, shall have undergone vaccination or other prophylaxis against all or any of the diseases as may be prescribed. Some of us here, some of us on this program today have had to obtain yellow cards over the course of your lifetime for the purposes of traveling from one country to another. Countries have a right, and they have acted consistently on the right, to say if you are coming into Nigeria, or if you are coming to the United States, or you're coming to the United Kingdom, you must be vaccinated against so and so diseases. The yellow card that we obtain is actually called the International Certificate for Vaccination and Prophylaxis. That's what it is. These things are things that already exist and which we already adhere to as a matter of course. You cannot enter the United Kingdom today if you have not met certain vaccine provisions. You cannot travel to the US or to any number of countries if you cannot show that you have been vaccinated. You have been vaccinated against certain diseases. This is an existing framework that already exists in the country. We have just seen in our country and in the rest of the world, which we have simply adapted into this legislation. Now, Section 47 deals specifically with vaccinations in the time of infectious diseases, right? So if there is an outbreak of infectious diseases and a vaccine exists, that is, it has been subjected to trial, it has been approved by our country, it has been approved internationally, that vaccination, this law allows the DG to mandate that, you know what, we Nigerians have to be receive this vaccination, or people who are at risk of infection need to receive this vaccination. Again, this is not new under Nigeria's law. Section 13, subsection 4 of the Child's Rights Act, which was passed in 2003 as a federal law and has been domesticated in about 26 states, makes immunization and vaccination compulsory for children. Section 13, subsection 4, it mandates a guardian of a child to make sure that their children or the people that the people under their care are vaccinated against certain diseases. And that same act, in section 13, subsection 5, makes it illegal. That is, it prescribes punishments for parents who refuse to vaccinate their children and all of that. And in section 13, subsection 6, grants the courts the power to actually instruct or mandate that your child be immunized. So if you refuse for whatever reasons, the court can intervene and say, we're taking this child to go and receive vaccination and receive immunization as the need may arise. There is something I need us to note. When it comes to the issue of public health, public safety, and public defense, individual rights must succumb to the greater good. Last week, I was having a conversation with somebody, and he brought up an analogy that has stuck in my mind for a very long time. And I think I will repeat that analogy here. When you think about public health, think about it in this regard. Any one of us here can decide to go to a bar or to a public or sit in your house and drink alcohol. That's what I mean. And drink to your heart's content. You can drink 1 bottle, you can drink 2 bottles, you can drink 3 bottles. It may not be good for your health, but the government is not going to intervene and say, stop drinking alcohol in your house, or don't drink more than 2 bottles, or don't drink more than 3 bottles, because that is your personal right. But the moment you finish drinking and you get into a vehicle to operate a vehicle, at that point, the government has the authority to intervene, because your personal decision has now become a matter of public concern. Your personal decision now has public health and public safety consequences. At that point, the government can and should intervene in stopping you from taking that decision, or in compelling you to take another particular decision. Again, I need to reemphasize, nothing we have done with this bill is outside the remit of Nigeria's law as it currently exists. The government of the Federal Republic of Nigeria, in section 45 of the Constitution, has the express authority to take action that may abrogate certain personal rights, where doing so is necessary for the public, for the protection of public health, for national security, for national defense, and for public safety purposes. This is the reality within which we already exist, and we have simply sought to build on it. Second thing I want to reemphasize before I leave is this bill is this document is a bill, and it is a proposal, and it still has a long way to go before it becomes an act of parliament and before it is signed by the president, if the president chooses to sign it. During that process, a lot of improvements will be made. A lot of things will be added, a lot of things will be removed, a lot of things will change, and the bill will be perfected. Because mind you, for this bill to pass in the House and to pass in the Senate, you need a majority of the votes in the House and a majority of the votes in the Senate. To achieve that majority in the House and in the Senate, you must make sure that the bill is acceptable to a significant swath of Nigeria's population, who are represented by their members in the House of Representatives and in the Senate. Every tribe in Nigeria, every religious concern in Nigeria is represented in the House of Representatives, and all of those people will have an opportunity to do what we call clause by clause consideration of this particular legislation before it becomes the law of the land. Thank you very much,
Dubem.